I am Faraz Fazal Sheikh Advocate. Sir, this is the case 6579, year 2022. The applicant company is Messrs. Bias R. The respondent is the state of France. I am representing the state of France here as an Attorney General. The skeleton arguments are before your honor, and the copy has already been sent to the other party a week before. Sir, the respondent, me, resisting the application made by the Messrs. Bias are the applicant company. This is a cross appeal, in fact. The applicant is claiming that it had the right to set the price independently, while the situation is altogether different. Uh, in fact, Lotka Energy entered into an agreement with a consortium of three other companies. The sharing ratio were 34% of Mrs. Bias R. Bias R is a seller of gas to Lotka Energy. The price will be fixed by the mutual consent as per the agreement. 12% shares are held by the France, it is the buyer. TKUL having sharing ratio 54%, it's the buyer of gas and sell it to the general public of France. Uh, Sir, let I scratch the details of the case which had already been held. France had filed a petition against Mr. Lotka Energy before the French tribunal, whereby it was awarded that the interests of France as a shareholder of Lotka Energy has been damaged, as setting the price of gas purchased from Party 2 is unfair. Bias are Party 2 है as applied for arbitration against France before the arbitration of Institute of Stockholm Chamber of Commerce, whereby an award has been given to the other party, Mrs. Bias R, in favor of it. In September 2016, the French tribunal upheld the award of the Tribunal Arbitration Institute of Stockholm, Sweden, on certain grounds. Now, both parties come up in before this forum and file the petitions on certain grounds. The French Court of Appeal has dismissed the claim of the state party and also dismissed the claim of Bias R against France, as these are against the Article V2A and V2B of the New York Convention, and declared that there is no jurisdiction of arbitral over Stockholm Chamber of Commerce, and as it is against the Constitution of France. Further, few questions of laws were framed and sent to the Chief Justice European Union for the answers. These questions were whether an arbitral award tribunal prohibited a party from bringing certain claims before a court of a member state. Second question, does the court of that member state have the right to refuse or recognize such an award of that arbitral tribunal because it restricts the rights of the courts? And the last question, sir, whether it has jurisdiction to hear the case under the rules on jurisdiction in the recast Brussels regulations. Sir, I have already annexed the following documents for the assistance of this court. These documents are agreement between the parties, evidence of breach of the agreement, order of the French tribunal between the parties, award of arbitration by the Institute of Stockholm Chamber of Commerce. Order of the French tribunal upheld the award of the arbitration. Institute of Stockholm Chamber of Commerce. Order of the French court, which dismissed the claim of the state party and also dismissed the claim of the Bois against France. The statement of this case issues are framed and are laid down in a separate page for the ease of this court. Sir, now let I sum up with my comments. No arbitration award or rule can ban a party to knock the court. Filing of appeal is the right of the parties that is vested under the law. Answer. Any award which confines the rights of the court is nowhere available in any law and as well in the laws of the France. Yes, under the laws of the land have proper jurisdiction over the case. Article V2A of the New York Convention empowers the court of a contracting state to decline the implementation of an award if they find that the topic of the distinction which prompted the award is not equipped for settlement by mediation under the law of the nation where parties are seeking the remedies. Also, V2B of the New York Convention energizes the court of a contracting state to reject an appeal, an award, when they find that such award or implementation would be in opposition to its public strategy. Sir, please find my prayer and conclusion as well. Sir, since both parties come up into appeal before the French Supreme Court, the Court of Succession, whereby the initially stay has been granted and the question of laws are framed and sent to the Chief Justice European Union, answers to these questions parawise are: no arbitral tribunal can prohibit a party from bringing certain claim under the grab of some award or any appeal, any decision, any finding, anything, sir. The court's right would be restricted. If so, it is not allowed. Yes, it has jurisdiction to hear the case under the rules or jurisdiction in the recast Brussels regulation as well, but up to the extent that the rights of the courts would not be restricted, and also there would be no prohibition to knock the doors of the courts. Sir, Article V2A, let I re-emphasize on Article 2 V2A of the New York Convention. It enables the courts of a contracting state to refuse recognition and enforcement of an award if they find that the subject matter of the difference which led to the award is not capable of settlement by arbitration under the law of the country which led to the award is not capable of settlement by arbitration under the law of the country where recognition and enforcement are sought. Sir, further, Article V2B of the New York Convention also enables the courts of a contracting state to refuse recognition and enforcement of an award when they find that such recognition or enforcement would be contrary to its public policy. Sir, the case is very much clear, and it states that no arbitration award can intervene, can interfere, can disturb the rights and even the rights of the parties to knock the doors of the courts. So, at this moment, I must say, there is no value of these Stockholm Chamber of Commerce arbitral award. My submission is to please accept the petition of the state of the France and may please reject the application made by Boyce R. in these questions of law framed before your honor. The case of the Boyce R has already been dismissed by the court, and please accept the petition by giving an award to the state of France. Thank you, sir.